Okay. All right. So, good morning. Happy Friday. Happy June 12th. Can't believe it. Halfway through the month of June. Telling you, this month is going to go super quick. All right, we're going to be discussing the as is clause. The as is clause. Most agents understand the elements of an as is clause. Most agents, unfortunately, do not understand the as is clause. Okay. So, what every agent must understand when it comes to staying compliant and to reduce the risk. Now, for me, I have two different hats, right? Hat one is the broker compliance of me. Hat two is the real estate broker, the transactional, right? And how I portray the elements of an as is clause. Now, just so we're all clear and all on the same page, an as is clause is already part and it's already incorporated into the purchase agreement. Okay. It already illustrates and it states the fact that the property is in its as is condition, that the seller does not have to do anything as long as they divulge or disclose any material facts regarding the property, right? With that, it gives the perception and how you maneuver all of this, right? Remember, even new construction are going to have some issues, all right? They may not be issues significant like a 1930, 1940, 1950, 1960 home, but it may still have some issues that you have to understand that even new construction, they may stipulate as part of the agreement and that is an as is condition, right? So let's dive right into today's topic. Again, if you don't know who I am, my name is Simon Cazares. I am the team leader and the broker for multiple offices. And now I'm pushing almost 30 years in the real estate industry. So I'm so grateful and so humble to be part of this. Again, all of our sessions are recorded. They are on our YouTube channel. And if you're interested in getting a copy of the presentation, just send me an email. I'll be more than happy to do so. All right, so let's continue. Right. So today's objective is really what is an as is clause? What does that actually mean? Right. What it does not protect. And the seller's obligation, despite as is, buyer's right and contingencies, right? How to protect the buyer, how to protect the seller, and the do's and don'ts. But ultimately, it's really the negotiating strategies around it, right? And the common compliance mistake that agents do, and then the bigger picture is the reduction in strategies for all agents, right? And I want you to have an open mind, folks. Okay, what I mean by this is, look, our job is to navigate and get it to the finish line, right? If you represent the buyer, represent the seller, the goal is to get it to the finish line. This is why it's vital and important for all of you to understand the ins and outs of the contract, right? And more so of the purchase agreement, the listing agreement, and disclosures, because all of your answers are there, right? All right. What does it say up here? Anyone?
What
Louder?
is as is sale?
What is an as is sale, right? Okay. Does anyone know what an as is sale mean?
That
Anyone want to give it a jab?
Yes, Simon, that means that the way it is, there nothing can be more done. It's just whatever you see is whatever you get.
100%. All right, you get a star. Thank you. Absolutely. And as is really here. This is the property in its as is condition, meaning what you see is what you get. Does that make sense? Okay. We're not going to do anything but sell it the way it is, right? Maybe the seller has already done much work, throughout the years, and they're not going to do anything, right? Even if the buyer puts a request of repairs and says, I need you to do all of these repairs. I want you to do all of these replacements. Okay. I want you to reduce the price of the home. or give us concession in lieu of the repairs. The seller can says, I'm sorry, but the property is being sold in as is condition. Okay. So that's really what it means, and what it stems from is all properties are sold in its as is condition. So let's define and break it into segments, right? The seller is offering the property in its present physical condition as of date of acceptance. Okay. Meaning, as soon as the property is ultimately executed, let's say you're the listing agent, right? You go to a listing appointment, right? You go through the comps, your marketing strategies. What are you going to do to help me sell my property? I sign an agreement, okay, saying I signed the executed listing agreement, and now I'm ready to go to work, right? Now, can the seller do any minor or major stuff during this transition? The answer is yes. The seller may say, look, before you go live on the market, I want to make sure that I do a cleaning, right? I want to make sure that I do a thorough cleaning. I need to declutter. I need to do this. I need to do that before it goes live on the market, right? And I get it. And that's fine. Okay. And the seller has every right to do that, every right to do that before it goes live on the market, right? But the present physical condition as of date of acceptance, that's when the buyer submits an offer, negotiations, and ultimately, right, both the buyer and the seller come to an agreement, and that's where the acceptance comes into play. And that's where now the motions of the process goes, right? So it's not a disclosure, it's no inspections, no contingencies, no repairs, no liability. As is does not mean any of these, okay? So what it says is really that, like Susie was saying earlier, right? What you see is what you get. Now, the buyer has every right to do any and all inspections, okay, to make sure they satisfy themselves to the overall condition of the home. Meaning they can do a physical inspection, a plumbing inspection, a sewer inspection, a roof inspection, electrical inspection, foundation inspection, chimney inspection, whatever. They can do all that within their time frame, right? So under paragraph 11, no extra as is wording is already stipulated on there. So if you go to the purchase agreement under that paragraph, it has the wording that all properties are sold in as is condition. Okay, so there's no need, and it really it really makes me laugh, where a counteroffer from a listing agent says on the counteroffer, the property is being sold in its as is condition. That's annoying because it's already on the contract. I don't know why they have to do it, but they do, just to what, reinforce what's already on the contract. Okay. A good real estate agent knows, right? Because if you study the real estate contracts, you know the ins and outs of it. It makes us chuckle and laugh that, hey, maybe this agent doesn't understand. And that's going to give you the leverage necessary to negotiate for your clients. Okay. But it already has that information on the contract. Don't be that agent that reinforces and adds the language again. And I see that often. You know, I used to be the compliance officer for many, many years. I saw numerous transactions on a weekly basis, on a monthly basis, and I would see the language that said on the seller's counteroffer, hey, by the way, just letting you know the property is being sold in its as is condition.
And seller will do no repair.
And sellers will not do any repairs. Okay. How do we know that? Do we actually know that the seller is really telling us, or is the agent doing it on their own best interest, right? Because they don't want to negotiate. They want to make sure they're protecting the seller. And I get it. But I can tell you from personal experience that a lot of sellers do not know the ins and outs. Maybe a few will say, look, Simon, I am selling the property the way it is. I do not want any buyer that's going to ask for any credit concessions, repairs, or replacements, or a price reduction. And I'm not going to do it. Okay, I get it. But I would not put that in the language because you're basically putting you're basically putting yourself in a position that will not give you the ammunition for negotiations. I'd rather be silent about that, right? And let them, because we don't even know if the buyer is going to ask for any type of credit. They may be happy that their offer got accepted and they're good with it, right? There's no need to add additional language if it's not necessary, right? So again, is part of that is the ambiguity, conflict of terms, and the increase of litigation, right? Remember, our job is to navigate the transaction to the finish line, not to practice law and what it dictates, right? That's why we have attorneys that do so on our behalfs. Or the seller or the buyer can speak with their own representation as well. They have the right to do so. And I would encourage it even more. Push them, say, hey, get a second opinion, speak with your attorney. That's good. Don't fear that. Take it as a way to help navigate it so that way you're protected and you're not compromising yourself in a position. Because, it's a very delicate situation, right? That, in the mind of the buyer is what is the seller hiding? Why do they need to add that language that the property is being sold as its condition? And I can tell you from personal experience, buyers think of that like, what are they hiding, right? But there's nothing to be hidden. It's just understanding that the seller does not have to do any type of repairs, any type of concessions, okay, or replacement. As long as they divulge and disclose it through the seller disclosures, you're protected. They cannot come back to you and says, hey, you lied to me. You failed to tell me. You just did not disclose that to me, right? So be mindful about that and be very, very careful. And again, it doesn't matter who you represent, if it's the buyer or the seller. So as is clause does not eliminate, right? Doesn't eliminate the number one thing. Okay, it doesn't eliminate any of this stuff here, right? Seller must still provide, okay, a TDS, a SPQ. We as real estate agents must also divulge and provide the habit, any material facts, natural hazard disclosures, or any known defects. Okay. As is does not protect fraud, concealment, or failure to disclose. Okay. And what that means is this, folks. If the seller knows about something, okay, and that is brought to your attention, and the seller is saying, do not say anything about that, or I'm not going to put it on any of the seller disclosures. What should your response be to something like that? If the seller says, I want to conceal that, I don't want to let them know that there's a small leak when we expose one of the walls, and I just don't have the means, or I don't want to take care of it. I patched it. I'm going to sell it. You said it's as is, but there is a leak behind. What should be your position on that? Yes.
I think that you should not accept that, and you should say in a kind way that we need to disclose everything. It's for your protection.
Yeah. Absolutely. Thank you. You were saying? Yeah, go ahead.
It protects us too as a realtor.
Yeah. Well, they told you, right? They told you that, they're concealing something, right? They're not being honest about it, right? Absolutely. For your own protection, Mr. and Mrs. Seller, I'm not going to put myself in a compromised position. I don't want you to be in a compromised position. Not that, this can go in many directions, right? So it's best to disclose it or fix it. Fix it. Okay. But the position as a real estate agent is for us to disclose it, right? And if the seller is adamant about that, okay, then what should be the next to that? What do you think you should do or say? Steve.
I've ran into that situation, in the past, and I'm really blunt about it, that
Yeah.
I will not be party to a fraud recovery. Okay. Either we disclose or you fix it, or I'm not the agent for it.
Yeah.
I said, and 99% of the time, the sellers really will follow through on either disclosure or really more of a disclosure issue. Most of the time, they're not going to leave a problem. It's the gray areas. It's all the what about question. Well, what about this? What about that? And I said, anytime your questions, it starts with the what about, you disclose. When in doubt, disclose.
100%. Look, folks, it's not going to kill the deal if there's issues with the property. If priced correctly, it'll sell. Someone will buy it with a condition. Okay. I would hate for you to be in a compromised position and ultimately you are now caught in a litigation because the buyer feels that there was concealment that the seller or you knew, not just may this kill the deal, but now you may be included in damages. Okay. And on top of that, you may also be in a position that it may jeopardize your license because you knew and you failed to do so. And to Steve's point is, yeah, there is no listing, and I'll repeat, there is no listing or no commission that I will take if I'm ever in a compromised position. My license is the most important for me. That's my moneymaker. That license provides my family, the means, right? So I would not jeopardize it for anyone, regardless of the commission. It may be $100,000 commission. To me, it's not worth it. Okay. And if we don't see eye to eye with the seller, then I have no problem pulling myself out of this and let someone else, because that $100,000 commission can be $500,000 in damages. Not worth it. Yes, sir.
Our E&O does not cover if you are then found guilty of fraud. Okay?
Yes.
Fraud being intentional, concealment, or deceit.
That's correct.
Okay.
Yeah. Good point. Good point to state. Yeah. If the errors and omissions finds that you also were concealed information and they can prove it, then you're basically on your own. There will not be any coverage. Someone on Zoom said something?
Yeah, Simon, I have a question. If the roof, let's say, had a hole and it was fixed before the listing was live, do you still recommend the seller to enclose it in the SPQ that it was fixed?
100%. Yeah.
It requires it.
Yeah. Part of the SPQ, it says that seller, are you aware, right? And it has a bunch of stuff, and then you have an explanation. I would, because what if something does go wrong, even though the seller fixed it, but something goes wrong and we didn't divulge that now leads to another issue somewhere else, right? So I'm looking at the bigger picture. For me, disclose everything. Okay. If the deal is going to fall apart, I'd rather fall apart that the buyer knew what they were getting themselves into. Look, it's a protection for both you and the seller. And the way you position yourself, Mr. and Mrs. Seller, I am doing my fiduciary responsibility and duty on you to protect you. Okay. I understand that might be a concern to the buyer and they may want to try to negotiate, but that's why you hire me as a great negotiator to navigate this for you on your behalf. Okay, because all properties are sold as is. I'd rather say, yeah, there's a puddle of water, but the seller is not going to fix it. You take on it. And that's okay, as long as you divulge and disclose. Most lawsuits arise because the seller or the agent knew something, not because the property was sold in as is. Remember, if you or the seller knows, or if you see something, you jot it down. You put it in your log as a backup, as paper trail to protect yourself from any later litigation. Just saying.
Simon, one more question.
Yes.
I'm about to take a listing where this is a trustee, not a trustee, it's an executor, and he's selling his aunt's house, which he's never lived in. And the aunt just passed away, and he's going to sell the house. So, I mean, at this point, of course, we can say that the seller never lived in the house, but then I should just go and dig and ask more and more questions, whatever he found out during his cleaning process, right?
Well, yeah. I mean, even a successor or an executor to the trust, if they know anything about the property, it is to their advantage to divulge, even though they never lived in the property, um, but they know something or a little bit of history, then it would be to their advantage to disclose it. I rather disclose than try to conceal or not disclose, because I can say, well, I never lived in the property. I get it. But remember, there's attorneys out there that will find one way or another to twist things and make it look compelling. And now you're kind of in a compromised position, in my opinion. I rather play it safe. If you know, divulge and disclose, my opinion. Okay. Buyer rights that survive as an as-is sale, right? Inspection contingencies, right? The buyer has every right to do a thorough inspection of the property. That's within your contractual rights to do so. It says on the contract. And if the buyer does, fantastic. If the buyer doesn't, that's also okay, but they have to understand that by not doing a thorough inspection, they cannot come back after and says, well, you failed to tell me about all this stuff. Well, you had your right. The seller didn't know, especially what's behind these walls, right? We can see the drywall, but we don't know in the inside of what's happening, right? Or up in the ceiling as well, or up in the roof as well, right? That's why the buyer has the right to exercise and do as many inspections as they want. And most buyers just do a general inspection, and they base their decision based on the general inspection. But also acknowledge to your buyers the importance that the buyer read the reports, right? Because they try to throw it back on us and ask them, did you read the report? No. Okay. Well, why not? You paid for the report. This is an inspector that went in there and evaluate the condition of the property. Okay. It's important for them to understand what they're getting themselves to, right? Because all properties are sold in as is condition, right? But if a buyer does decide to not do any inspection, there is another position, right? They have the right to waive inspections, and there's a form for that as well. Okay, I don't encourage it. I wouldn't recommend it, but you got very sophisticated buyers or investors that they know what they're doing, and they have contractors, and they're okay taking on a problem house, and that's okay. But in that situation, protect yourself by having a waiver that, hey, buyer chose under the broker's advice to not do any inspection, have them sign the waiver. And that's your receipt. That's your proof. If that buyer comes back and says, hey, we found out about this. Well, you chose not to do any inspections on the property, and that all properties are sold in its as-is condition. Well, Simon, the seller knew about that. Yeah, okay, yeah, I agree, and the seller should. Let's look at the disclosures. Oh, here it is. The seller did divulge that there was issues with the roof. Okay. As long as the seller divulge and knows of any conditions with the property, okay, it can be as little or as big, right? Divulge it. It's best to protect yourself and all parties. Sir.
That's why it's really important when you are working with the buyer that it is really important, especially when you are getting the disclosures from the listing agent side, especially the SPQ and the TDS, not to just have your TC just
That's right.
sign them over, for you to actually physically read the TDS SPQ and actually review it with your buyer so that you can actually see what the seller truly is or is not disclosing.
That's right.
And not just only just have it immediately signed away, because nobody reads the darn DocuSigns.
Yeah.
And so it's a good practice to be able to
Yeah.
of all the disclosures for review, that the TDS and the SPQ are the ones that you're looking for.
Absolutely. Yeah. I mean, we love DocuSign, but it's also putting people complacent because they're just click, 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 and but not really reading the document itself. So part of the buyer's right is inspection contingencies, right? Buyers retain the full right to do any and all investigations regarding the property. Repair negotiations, part of the process, buyers may still request the repairs. I've even seen situations, guys, where the listing agent on the seller counteroffer, property is being sold in its as-is condition, no repairs will be done. Don't ask. The buyer does their due diligence and it says, holy moly, there's a lot of crap here that needs to be done. You still can submit a request for repairs. Okay. And I would encourage you, because you're taking care of your buyer's best interest, you're still going to submit it. The listing agent will say, didn't you get the seller counter offer saying that the property? I get it. I'm following my buyer's request. Listen, at the end of the day, we either don't try to find a solution, we back out, you're now back to square one. You now have to disclose any and all materials of this new finding that my client's inspector found, or try to work with us. Try to make it a win-win, folks. That's the beauty and the dynamics of real estate negotiations. Okay, does that make sense? Okay. And then cancellation rights. If the buyer and the seller cannot come to an agreement or a meeting of the mind, hey, the buyer has the right to cancel within their contingency timelines. Remember, it defaults at 17 days, right? 17 days for the buyer to do their inspections, right? I would not wait till the last minute to do them. You immediately, once you get the acceptance within a day or two, you need to be calling inspectors to get out there. The more the merrier. Yes, there is a cost, but that's the cost of risk that the buyer will at least know what they're getting themselves into. Okay. And if this is not the right house, at least we knew. We don't want it to be a money pit house, right? Have you ever seen that movie with Tom Hanks called The Money Pit? If you haven't seen it, I would encourage you to watch it. Everything in that house goes to shambles. I think the whole house comes down, right? So just be mindful of that. And, as you're navigating this process, and this is where most deals fall apart too. Okay, this is when most deals fall apart, is during the inspection contingency period, right? Our job as real estate professional is to stay in communications with the listing agent and make it a win-win for all, right? Just because the seller is putting a wall, because the listing agent is putting a wall, doesn't mean you cannot penetrate that. This is why it's important to be able to communicate and the engagement. That's why professionals know how to maneuver. I've seen some situations where property is being sold as is, no repairs, to giving credit and concessions. How about that? You're going to look like a superhero, in my opinion. Seller's duties to maintain property through the escrow period, or through the close of escrow. Even if it's an as-is sale, the seller must still maintain, the same condition of the property, right? So if you're in escrow, seller cannot just say, well, it's going to be the buyer's responsibility if we have a water leak, right? Or roof leak, or fire, broken windows, or appliances that are part of it, right? It's still your house. And if you're the listing agent, you need to, one, disclose, hey, we have a water leak. We're just bringing it to your attention. But more so, the seller still has to take responsibility to get it fixed. Oh, we're closing tomorrow. That's going to be the buyer's position. Well, that's a material fact, and that's concealment, and that's a problem. The seller can come back, hire an attorney, and sue the buyer, or excuse me, sue the seller for non-disclosing. Okay. Now, the question here is, well, Simon, you're saying that the property sold it as is condition, right? And during escrow, we have a pipe that burst. Now there's a bunch of water, but you said the property sold it as is. We disclosed the water bust. Does that mean that the seller has to fix it? What is your take on something like that? Okay, does the seller have to fix it? Or because the seller says, hey, I'm letting you know, I'm disclosing, I found out, but property sold it as is. I'm not going to repair it or fix it. Is that okay in your opinion? How many
Simon?
say yes? Yes, yes, yes.
Because we have a walkthrough, that means however the buyer saw the property from day one before getting into escrow, it has to be in the same condition when they close it.
Yeah, beautiful. Good job. Yeah, absolutely. Because remember, they bought the they submitted an offer based on the condition of the property. At the time of the offer that was submitted and accepted, there was no water leak. There was no roof leak. Okay. There was no window broken, right? So in essence, that's an argument that the buyer and the buyer agent have a compelling position to say, I disagree. Look, we bought it with the intent that there was no leaks on it. Yes, thank you for disclosing, but you still have a responsibility to correct it. And yes. And if they don't, you have a position to, even after releasing physical inspection contingency, maybe the right to cancel. And any attorney will navigate this as well. And I've been in circumstances, situations similar, where we're able to defend the buyer, cancel escrow, and get the buyer's full deposit back. Okay. So just be mindful if you're the listing agent in this situation. Well, property sold it as is. We disclose all this information to the buyer. Well, no, if you read the contract says define is, and like you said too, Susie, this is on the VP, right? That the property has to be in the same condition as originally the offer was submitted. Something to those words. Yeah. Yes. Yeah. All right.
Quick question. What if we find that out in the walkthrough and all the contingencies are removed? And we find out that there's just, whatever you said, the burst of the pipes or whatever issue that we just found out not in the same condition as we saw it before we got into escrow. What do we do then?
Well, it still hasn't officially closed, and that's why you have a VP, right? A final verification walkthrough to make sure. And really, the essence of a final walkthrough is to make sure that whatever the seller and the buyer agreed to do, that it has been done, right? That's the whole purpose. It's not to renegotiate. It's not even to cancel. But if a situation occurs where now you find out that there was let's say a water leak, then you're immediately going to let the listing agent know, right? And the listing agent should be there as part of the walkthrough as well, So be mindful about that, because I've seen situations where the listing agent is not there with the final walkthrough, right? You and the buyer agent should be there as part of the process, right? Because one, you now can see what is happening, right? Not to say that buyers are bad people or agents are bad people, but I've seen situations where they do something to now argue or come in a different way to say, hey, this is broken. And it might have been an accident by the buyer, and now it's putting blame on the seller. But if you were there, you do a quick check to make sure before the buyer and the buyer agent even arrive. So that way, okay, that wasn't like that prior. So something happened, right? So now you have a position to put yourself in, right? So going back to your question, is you bring it to the listing agent's attention, and you come with a solution, right? Hey, you know what? Again, we bought this property with the intent that when we saw it, there was no issues. We're asking you for you to fix it. And maybe the seller says, I don't want to fix it. I'm just going to give you credit. And as long as the buyer is okay with it, then we can continue in closing. All right. Or you can delay the process as well, too. Now, it's kind of iffy because once the buyer releases any and all contingency, it puts a compromise and exposure to the buyer's deposit, right? You got to know how to maneuver and navigate that, but you try to find a solution for that, what I call win-win. State local retrofit requirements. Okay, so just a couple of things that you need to be mindful, right? What are required as again as the as is, right? Now I might get a debate over this. I'm just generalizing, right? And most of the information that I gather and pull is straight from the California Association of Realtors. Okay, do you think we should have smoke detectors in every home? Yeah, pretty much, right? Carbon monoxide, water heater bracing, local retrofit ordinance, sewer lateral requirements. Some cities do, some cities don't. Point of sale compliance, right? City of Lawndale, City of Compton have inspections that they must do prior to transferring of ownership, right? So part of the compliance and obligations that may exist regarding this is, yeah, these are all part of the process, but there's credit, there's responsibility, who's assigned to it, timing, and you can also do some type of escrow holdback, right? But these are again some of the general stuff that all properties should already have, and if not, because sometimes the lender may not lend on a home that doesn't have these items, especially your FHA or your VA loans, right? Your government loans. So be mindful of that, right? And I've seen situations where it's a tear down. Well, what happens if it's a tear down, right? Well, we know as much as everyone knows that the buyer intent is to tear down and new construction. That's a whole different animal, right? So I get it and I understand. And for that, then you still want to protect yourself, that says, that the seller plans not to put a smoke detectors and all this stuff with the intent that the buyer is going to tear it down and completely rebuild from there, right? And that's everyone's position to cover your position, right? Biggest agent mistakes that we see. All right, so the mistakes that we see is mistake number one, responding property sold in as is without specifically rejecting repair creates dangerous positions here, right? Correct, the seller declines buyer's request of repairs. Number two, seller believing as is removes disclosure duties, creates massive liability, right? No, the seller still has the right to divulge and disclose any material fact regarding the property. Mistake number three, buyers believe all rights are waived. Okay. Investigations, contracts, cancellation rights still remain, right? So even in an as is, position, the buyer still has to understand there's still some type of layer of protection for the buyer, right? And part of that process is if the buyer now finds out a new material fact about the property, guess what the buyer has? They have 5 additional days to do an additional thorough inspection and evaluate the situation. And ultimately, if they feel that it's going to be too much, they have the right to cancel, even if they release physical inspection, because this is new to everyone, new to the seller, new to the buyer. That may be a position where the buyer says, look, the roof collapsed. The seller selling the properties as is, they don't want to fix it. We don't want to buy it, We're going to go and evaluate. We're going to get opinions of cost of repair. But, the buyer is in the burden and responsibility. Once it closes, keys are exchanged, title is transferred. It's the buyer's responsibility, right? So it may be a cost that the buyer may just decide, I don't want this property. And because of that, the buyer may have some rights to cancel and retain their full deposit. Okay. Mistake number 4 is agents interpreting law or giving legal opinion, explaining the process in a timely only, right? So be mindful and very careful, right? We don't practice law. We don't give taxations. We always direct them to the legal experts, right? Our job is just to sell property. And if everything seems to go sideways, and it'll go sideways really quick, remember, always say, buyer, please, speak with an attorney and get, legal advice on your position, right? And that puts us in a position of protection, right? Because we have now allowed the buyer to do what they needed to do to make sure the buyer is protected too, right? And now it's not coming from us; it's coming from a legal standpoint, right? I'm dealing with a real estate transaction where we represented the buyer, one of our agents here in the office, and the seller and the listing agents, and there's 2 co-listing agents on this. And, it was due to HOA documentations. The seller was adamant about providing current HOA documentations. They provided HOA documents from 5-10 years ago. And when the buyer started doing a little bit more research and ultimately went directly to the HOA company and got the most current, there was a lot of things that the buyer would be responsible that the seller failed. And because of that, the buyer now wanted a different approach to give some type of credit and concessions. And the seller says, nope, 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 property's being sold as is, and completely fires the listing agents and then shut down. And we ultimately, I was involved in that back and forth for 2.5 weeks, and I thought we got it taken care of. And then the seller left field from nowhere just says, nope, we're done. We're not going to move forward. We're canceling on the buyer. So we ultimately advised the buyer to get an attorney, and the attorney now is involved with the seller directly. The agents basically clean their hats. The brokers involved, because again, it was two brokerages. They're basically saying we're on standby, but this is a dispute between the buyer and the seller, and to a sense, it is. It sucks, but ultimately the deals are between the buyers and the sellers, not between the agents, right? We just got to step back and let them kind of figure it out. Any questions regarding mistakes here? All right, so some negotiations. All right, so seller strategy. Seller will make no repairs. Seller declines requested repairs. Okay, prefer alternatives. Right, there's credit, price adjustments, or closing concessions. Right, as part of it. Yeah, part of the negotiations, the seller may not want to do any repairs. Right. Maybe it's an elderly couple, right? Elderly family that they just don't want the burden to do any repairs, right? Whereas a younger family or a couple might have the energy to say, look, it'll cost me less to do it myself. It's easy, I can get it done, and I'm saving myself money, and the buyer's still happy with the property, right? So it really depends on the situation. It really depends on the situation. Buyer strategies, conduct a thorough inspection. Folks, listen, if you represent the buyer, make sure you're pushing them to do any and all inspections regarding the property. More so if the property is, 30, 40, 50, 60 years old. You're going to find something, right? If the plumbing hasn't been replaced, if the sewer line hasn't been replaced, get a thorough check on that, because that'll give a good indicator what they're getting themselves into, right? And that's going to help tremendously from any potential issues down the line, right? Because it happens all the time. The deal closes and now all kinds of stuff happen. Why does it happen after the deal closes? I don't know, but it happens. Okay. Kevin, who's in one of the office, I remember many years, he represented I think it was the buyer he represented. And as soon as we closed escrow, within a day, the sewer busted. Literally, the sewer busted $15,000, $12,000 later. Yeah. Who's responsible for something like that? Right? Well, the buyer was responsible for that. Okay. I don't think the seller's intention was to hide that. I mean, a sewer line can give, right? But a good indicator is if a home is 40 plus years, you may want to get a thorough sewer inspection of it. Review permits and disclosures, request specific repairs or credits. Understand the contingency timelines. Yeah. So don't be that agent that waits to the very minute. It's 17 days and you're barely doing inspections on the 15, 16 day, because a good listing agent will send you the notice to perform and release that. And if you can't perform, they're going to cancel on you. And there's nothing you can do about it. Okay. So be mindful. Get those inspections done as soon as possible, as soon as practical. The sooner the better. That way you have plenty of time to negotiate terms and still be within your time period. If it works, great. And if it doesn't, the buyer has the right to cancel and retain their full deposit. So keep that in mind. From a risk management point, so everything should be documented, right? Wins and lawsuits, right? An agent that has a very good paper trail will ultimately be in a better position. Okay. Like for me, in my role, I try to put everything in writing. Okay. We're dealing with another situation with one of the Long Beach agents. He represented the seller. The seller had like 10 listings he gave to the agent. 10 listings. That's awesome. But now 5 of those listings were canceling. Okay. And the reason we're canceling is because the seller is not happy with the agent. And he made it very clear on the emails that he's been sending, threatened to hire an attorney, threatened to report him to the Department of Real Estate, right? And I gave him the pros and cons. I says, look, I understand, because the argument that the agent was debating is, I reduced my commission. So am I allowed to at least ask for some of that because I reduced and discounted my commission? I told him, look, unfortunately, no. And the reason is because every commission is negotiable. What you negotiate, it's on you. That's the standard seal that you agree to that commission, even if it's 1.5% or 2%. You cannot come back and says, well, I discounted when I should have got 3%. I'm trying to argue now. I says, it doesn't work that way. So be mindful and careful of that, right? So document wins, lawsuits, right? Inspection recommendations, reports and negotiations, everything you compel, you put it in a file, in a folder, right? So when you represent either party, make sure you have a folder and just throw everything in this folder on your computer, right? It'll save you the heartache. And now you have a compelling chronicle order in a position to articulate your position on why you feel the way you feel. And if you're an agent that's all over the place, that's a problem trying to compel your argument, right? And more so, it doesn't help the attorney if we're trying to navigate this potential issue to diffuse or de-escalate the situation, right? Seller response, buyer acknowledgement, disclosure deliveries, and contingency removal. That's all part of the process in high risk in a transaction. Keep all of that text message, emails, signed documents, everything compel into one place because you just never know. This may come back to haunt us, right? And if you're an agent that has everything dialed in, then it just makes it a whole lot easier to protect yourself, right? And it could be the little small things. It's like a text message, the seller saying yes or no to it, right? And here it is. There it is in black and white. Listing agents best practice over disclose, right? I'm a true believer is the more you say, the better. Simon, I don't want to kill the deal. I get it. But I also don't want to be in court defending my case, right? Recommend inspections, right? Always make sure you're pushing those inspections, right? Wow, do you think I need it, Simon? I'm not buying the property. You want to know what you're getting yourself? Get an inspection. Get a sewer, right? And there's a form that illustrates all of the different types of inspections a buyer can do as well, right? So push it hard. Avoid minimizing defects, right? Remember, it may be something small, but that small can ultimately be something bigger in the future, right? We're not experts. Don't pretend you know from experience. Let's get the right people here, especially when a house is tilted, right? I've been in houses where the house is tilting and you're walking and you feel like you're at Universal Studios back in the 80s, where you would go through this tunnel and you feel like the tram was almost flipping over. It's like, it's crazy, but there's houses that foundation is bad and you don't walk straight, you're walking kind of at an angle, right? Document everything. Put everything in writing. I cannot emphasize the importance of putting things in writing, right? Counter repairs, requests, all of that. Buyer's agents, best practice. Slow buyers down. Don't rush, right? Remember, everything is negotiations. If you can retain 17 days, then retain it, right? But what about when a listing agent throws that we're only giving you 5 days to do an inspection, right? That's rapid fire, right? 17 days to 5 days. And I've seen listing agents being aggressive. Why? Is because they got other offers. They're just shopping to see who is willing to play the game. But be mindful, if this is a first-time home buyer, not a sophisticated investor, they may not have the same mindset, right? That they can gather and do everything within 5 days. So be practical and use some common sense as well. Encourage specialized inspections, right? That's again your sewer inspections, your electrical, right? Getting a roof done inspection. Don't just rely on the general inspection. Get an expert that does roofs for a living and get a quote on what it's actually going to cost to repair or replace it. Okay. Review contingencies and timelines carefully, right? Understand your buyer's position, because every contingency that you release is closer and closer to the buyer exposing their full deposit. And if the buyer fails to perform, the seller may go after damages and retain rights to the deposit. Never assume. As is removes buyer's rights, right? So never assume anything, right? Everything needs to be documented in writing that says, here, this is what it actually tells us, right? Because assumption can really put us in a really sticky situation, okay? And what better buyers and sellers do? They start blaming people. Yeah, it's like, wait a minute, why are you blaming me? Well, because you just happened to be in part of the transaction. Be careful. Hey, buyers and sellers can turn on you. Yeah, and they'll rapid fire is like, wait a minute, what happened here? And they start ghosting you. They're not communicating. They're upset, right? And I know it's like walking that eggshell with buyers and sellers, right? But here's how you protect yourself: documentation, text message, emails, right? Forms that you're getting them signed, right? Because now you can now say, here, this is what you agreed to. Hey, this is what we talked about. This is what we ultimately are trying to do. How do you want me to navigate it, right? So scenario discussions, right? Buyers request roof repair, sellers respond, property sold in as is, right? How would you handle that conversation? Okay. Did the seller clearly reject the repairs? Or no, the ambiguous must counter specifically, meaning, right? Yes, we know that all properties are sold in as is condition. Okay. We established that, right? But again, just because a property sold in as is condition doesn't necessarily mean that the buyer has no rights to ask, right? And I said it earlier, and I'll continue saying this. It doesn't matter. Look, you're trying to take care of your buyer's position and best interest. You still submit, even if the listing agent gets pissed. Simon, I told you that the property sold in as is. We're not going to do any repairs. I understand. But it's not me, it's my buyer. We're at the verge of potentially backing out. The buyer's just asking for some type of help here. And I understand if the seller doesn't want to, I get it, respectfully, then we will have no choice but to cancel. But I'm going to do my efforts as I was hired to help them get to the finish line. Yes, I know that you said as is. I know that it's on the contract sold as is. But the essence, that doesn't change that there is a problem. And they're only asking for this problem to have a resolution. And whatever resolution is, if it's repairing it, replacing it, giving us a credit, or reducing the price. My last is cancel, but we don't want to cancel. So I'm trying to work with you here to try to make this a win-win so we can get to the finish line. Okay. Yes, sir.
If you happen to get that listing agent who ends up being very assertive on not wanting to have his seller do his or her seller do repairs, I agree with you that it's probably more of the agent spewing that more so than the client themselves.
Yeah.
So one of the things that I have done on the occasion that I get this listing agent is being able to say, I understand. And as a result of this position, okay, you now know if my buyer now ends up backing out, that these items are now a disclosure item for your seller. And I'm going to make sure when this property is sold to the next buyer, okay, I'm going to follow up with that new owner to see if these items were disclosed to you, to that buyer.
Right.
Okay? Because that buyer then may end up having some action against your seller. So you may just want to consider having your seller look at our requests for repairs to take care of them or to give credit, because that is what I'm going to be doing in the position of your client not wanting to take any position of, correction.
Yeah.
I've been that blunt before.
Yeah.
And guess what? It moves the needle sometimes.
That's right. You have to have a little bit of understanding and passion, but you also have to have that aggressiveness as well, right? Thick skin, ladies and gentlemen, especially, don't compromise the position, right? Don't let ego get the best of you, but do what's best for your clients, right? And sometimes being firm and stern will push the needle, as Steve says, to the finish line. Number two, water pipe burst during escrow, right? We talked about it. Is the seller responsible? Likely, yes. Yeah. Okay. Number three, seller knew about water intrusion, but held because of as is statute or status. Is the seller protected? No. Potential fraud and non-disclosure claims, right? And it can cost the seller even more money, hiring attorneys, paying attorney fees, and all that. So be mindful of this, okay? And last kind of takeaways here, as is does define current conditions, limits repair expectations, and establishes negotiation posture. As is does not remove disclosure obligations. Just because it's as is doesn't mean that the seller doesn't have to do any disclosures or know about any issues regarding the property, right? They still have to divulge and disclose, but it's best to put that in front of the buyer and let the buyer make a decision. The buyer may be okay with it. I don't care. I'm going to fix it. I'm going to do what I want. I like the location. It's close to my work. It's close to the school, whatever the case may be. They're buying it for the emotional elements, not necessarily for the issues the property has. Waiver buyer investigations, protect fraud or concealment, and eliminate all seller obligations, right? So that is not what an as is. You still, as a seller, have a right to provide anything you know about the property. I've seen situations like this, right? That as a parent, right? And your parents have owned the property for 40, 50 years, right? And now they passed on, and now the children are in charge, right? But you know the history, right? Well, you're not on title, but you're the successor to the estate. Does that mean that because you didn't live in the property, does that protect you from certain disclosures? Okay. it's one of those kind of fine lines, right? Because I think of myself and my parents. My parents own multiple real estate, right? When that time comes, is and it's again my compliance hat that I'm wearing is how are we going to navigate it if we decide to sell the properties, right? And I know history, the current home that my parents live in, I grew up in it, right? So I know the bedroom, I know the ins and outs of the property, and to this day, I still go visit my parents, right? And they tell me what they've done, what not, they've not done to the property, right? So God forbid something happens and we end up deciding to sell the property, right? Yes, we're exempt to a certain extent. But for me, is they can twist it and say, well, that's the son of the deceased. The son should have known about this. The son should, they can use whatever. And it only takes a compelling jury by trial to diffuse that and say, yeah, you know what, I kind of agree that they should have known about this, right? That little instant can change the trajectory that will cost us money. I'd rather say, look, yeah, I know we have a pet cemetery back there. There's probably bones out there. Throughout the years, my sister loved dogs, and unfortunately, traditionally, we would dug away and unfortunately put the dogs in holes. I don't know if that's right or wrong, but being honest with you, I would disclose that, because there's people that are superstitious about that. Hey, I saw the movie Pet Cemetery. That's freaky. I'm not going to buy the property. You just never know. So always make sure that you disclose, right? I'd rather disclose than not disclose. As is, it's not a liability waiver. It's simply a statement of condition, subject to disclosure law, contract obligations, and contingency rights, right? At the end, it's really just about protecting everyone, right? Protecting the seller and protecting the buyer, making sure that everyone is happy. We have a very successful closing, and we all can now move on to the next transaction. With that, any questions?
Simon,
All right. Yes.
I'm super grateful for you, first of all, because first you solve every situation. When we speak to you, when we start out with an issue, you calm us down so much. First of all, by telling us how it's supposed to be, how it will be, what's the next step. So I'm honestly so grateful to have a broker like you who really solves things peacefully. Number
Yeah,
two,
thank you.
number two is that I'm just curious as far as this agent that had 10 listings, what was the reasoning behind the cancellations? Just curiosity. Why did he cancel? What was the reasoning? Why was he not happy with this agent?
Yeah, somewhere during the process, I think the seller was in a position where he was in a position that he was on notice to default, where he was going to go into foreclosure. So the pressure was on him, right? Because I all of these were investment properties, and time of the essence. Somewhere throughout the process, there was a break in conversations or something happened. I didn't go into the details, but ultimately the seller just felt that it would be best to cancel. And the unfortunate element is that the listing agent put a lot of time, effort, and energy into his marketing. And part of it is, look, we don't have a problem canceling, but look, I put a lot of expenses here. At least try to pay me for something. Now, also the situation here is that the agent is also a contractor. Okay, so he's a licensed contractor and did work in lieu that he would get his commission out of the his work out of the commission. I have a debate over that. I don't believe that we should commingle, right? You do one or do the other, but don't do both. Meaning, if you're a licensed contractor, congratulations. Hey, that's great. You do your contracting work and you might be great. That's great. But don't also be the listing agent. Just like I said, don't be a lender and a listing agent. It's not a good thing. Okay. It really isn't, right? You do one and separate. You can still do your other businesses, just do not commingle both of them, because that's kind of where he is losing money on this situation, right? So, yeah, it's just one of those very unfortunate circumstances. But the agent is okay. You know, he says, look, one way or another, I will bounce from it and move on. He was able to sell some of the properties and he made over six figures. So
Oh,
he made his money too as well. So, you know, it's not really a big loss.
the
All right.
last question I have, thank you, Simon. The last question I have is in our listing agreements, I never put any cancellation penalty. Do you recommend that?
What do you mean?
If the listing is canceled, the penalty for the seller to pay this much money or for the marketing or whatever it is.
Got it. Understood. So yeah, the listing cancellation does have language in there that says if there was some out-of-pocket expenses, marketing expenses that you're entitled. But it also has there too, where it says no compensation to be provided. So you also have the right to cancel and not retain anything. And that's your position, you know. To me, this is the way I see it. And again, this is just me. No listing is worth holding on to. Okay. If the seller is not happy with my services, I'm not going to defend my position. Hey, there's something that we just don't see eye to eye. I get it. I understand. I want to work with people that want to work with me. And I have no problem canceling and moving on. But, you know, it really depends on the circumstances in the situation, right? Because we do spend time, effort, and energy and expenses. Hiring a professional photography costs money. Drone costs money, right? Materials to host an open house, flyers, right? Your time and all that, right? So there is some expenses when it comes to servicing the property. Most agents will say, you know what, I'll make it on the next property, and they're okay with it. Some say, look, I spend a lot of money, and I've been able to help successfully navigate and have the seller take responsibility to pay us at least, you know, the cost at the agent. And this is again when the seller chooses to cancel early on the listing. Let's say we have a 6-month listing, and then 3 months they say, I want to cancel. They didn't give me the necessary time, right? But if the listing expires, yeah, there's no way I'm going to pay someone. You know, you had your time. You said 6 months that it would take you sell. We weren't able to sell it. You know, you're not entitled to any marketing expenses, right? So you got to take it for face value, depending on the situation. Okay. All right. Any other questions? No other questions? Okay.